Welcome to this video series on the making of international in Korea. We'll begin in this week of videos with a description and explanation of the core principles and practices of international law, and discuss the primary sources of international in Korea, such as territorial disputes, general and specific discussion of particular cases like Dokdo. Let me first touch upon the international law on territorial dispute and historical criticism. The terminology and context become more important here. The fundamental questions that relate to other East Asian territorial issues need to be asked, such as, did the legal concept or systems of territorial acquisition exist at the material time? Assuming they did, what kinds of role do they play in the resolution of relevant disputes today? If they do play a role, what effect will the significant factual and legal changes over the years have on factual and legal developments in the future? Applying these questions to the current territorial issues, for example, the Dokdo issue, we may further ask, can Japan claim the international norms that were prevalent during the era of imperial colonization? Was it impossible for Korea to make any significant contribution to the formation or standardization of the relevant legal norms because its status as a colonialized state? Should one or more parties to a dispute be unable to carry out a meaningful role in the development of a normative system, must the intertemporal law be utilized for the resolution of the dispute? Must the intertemporal law be claimed even when it may result in an unfair and defensive outcome? And must the intertemporal law be claimed when its results may result in impairment of jus cogens? We know that what jus cogens means is a higher or the compelling law. In the end, all these questions are related to the understanding of the one fundamental question, which is, in situations in which one cannot function as an actor, but only as an object in the application of existing normative systems, where the obvious logic or fact expressed as an actor are entirely misinterpreted and consequently act as restrictions, and where adequate channels of communication cannot be secured, how can one overcome the psychological discomfort of knowing that the status as an object will never change? Ultimately, the function of the historical criticism approach against the Eurocentric positive perspective of modern international law, the based on the third-party notions, seem to be the key challenges that is directly relevant to the search for solution to the Dokdo issue between Korea and Japan. There is a hope that, in the Dokdo case, an attempt will occur at the formation of fairer structure of international law in approaching territorial dispute, depending upon accommodation of the historical criticism approach emphasized by Judge Rangjeba of the ICJ. In international dispute resolution, the historical criticism approach ought to be emphasized as a theoretical alternative to creating more impartial international legal structure. Let me turn to the territorial dispute issues, general specific discussion of very particular case of Dokdo. The term Dokdo, which is the Takeshima to Japan, pertain to tiny islets that are in South Korea's position, located in East Sea of Japan, approximately 216 kilometers from the Korean mainland and about 87 kilometers from South Korea's the Ulleung Island. Despite its relatively small size, the islet have been a source of great tension between South Korea and Japan. Japan asserts that Dokdo belonged to Japan, while South Korea claimed that Dokdo is properly under Korean sovereignty. From South Korea's perspective, the Dokdo issue is not only a matter that concerns the legal arguments of which country has the right to Dokdo, but is an issue that must be viewed in light of the historical context of Japanese imperialism, broadly and more specifically, the Japanese colonization of Korea in the first half of the 20th century. The rhetorical force of South Korea's claim is based on the view that Dokdo was the first Korean territory to be taken at the commencement of the Japanese expansionism into Korea and that to the Asian continent, which culminated in Korea's eventual annexation and colonization and ended with Japan's defeat in World War II by the Allied powers. From the South Korea's point of view, a full appreciation of South Korea's claim to Dokdo requires a measure of empathy for Korea's status as a victim of Japanese aggression. South Korea's Dokdo claim is thus influenced by this perceived historical injustice. It is from this vantage point of victimization of South Korea's understanding of the Dokdo issue, and its arguments can be fully understood. Since Korean memory is preoccupied with moral judgment, the tenor of the tone of South Korea's narrative regarding Dokdo is primarily based on the perception that Dokdo was historical Korean territory that was stolen by Japan and then returned and repossessed by South Korea. The South Korea's claim of Dokdo started with the historical connection to and sovereignty of Dokdo due its geographical proximity to South Korea's Ulung Island. On the basis, given Korea's long-standing ownership of Dokdo, Japan's official incorporation Dokdo in 1905 and subsequent possession until 1945 was illegal, and thus had no bearing on the question of Dokdo's sovereignty. Further, once World War II came to a close, the pronouncement and decision of the Allied powers between 1942 and 1952, along with the ratification of the San Francisco Peace Treaty, confirmed and legitimated the Korea's eventual possession in 1948. Finally, South Korea's claim to Dokdo concluded with the declaration of the peace line in 1952 and South Korean actions in regard to Dokdo until the present day. In sum, South Korea has cast the Dokdo issue as one that concerns an historical injustice, the illegal taking of Dokdo in 1905 that was limited when Japan had to return Dokdo to Korea and South Korea was made whole.